Good evening and welcome to Borough Hall. My name is Diana Reina and I'm the Deputy Brooklyn Borough President. Welcome this evening to today's hearing. Here are two items on this agenda for this evening. Please note that this hearing is being recorded to comply with the public law for transparency. It will be available for viewing on Borough President Adams' website, brooklyn-usa.org, or on the One Brooklyn channel on YouTube. Web viewers may submit timely comments to askeric@brooklynbp.nyc.gov for Borough President Adams' consideration. Please call the item and let us begin. And before you do so, Richard, I just wanted to take an opportunity to welcome Councilmember Gentili, who's one of the two agenda items is located in his district. My former colleague, I thank you for joining us. And I also wanted to just thank our staff, Richard, our Director of Land Use, Olga, his associate, and our interns, Jason and John, and Anthony, who's our policy analyst on housing. Richard, you could call the calendar item.
Calendar item number 1160377ZRK.
This application submitted by Community Board 10 seeks zoning text amendment to remove Community District 10 from the aforementioned Board of Standard and Appeals BSA special permit. The special permit currently applies to 3 full community districts in Brooklyn, CD 10, CD 11, and CD 15, and a specific R2 district in CD 14. Approval of such action would not facilitate a specific project or include any new development. Approval of such action would no longer permit the filing for or approval of applications for the special permit for enlargements of single and 2-family homes within Community District 10, instead requiring enlargements to adhere to the as-of-right residential zoning regulations or rely on pre-established remedies, such as Zoning Resolution Section 72-21, Board of Standard and Appeals, variance, or an alternative BSA special permit pursuant to Zoning Resolution Section 73-621, enlargement, extension, or conversion of building containing residential uses limited to 10% increase of permitted floor area and lot coverage and or 10% decrease of open space ratio. God bless anyone who understood that. As the applicant, Community Board 10 has not taken a position on its application, though it is the long-standing policy of the board to seek this amendment to the zoning resolution. Would the representative for this application, Josephine Beekman, please state your name for the record and represent this particular application? And I want to just thank Josephine as she approaches the podium for all of her hard work. This was one of the first agenda items for the community district presented to me as I traveled the borough, personally in making sure that I had conversations with each community district in the borough. So 18 community districts received a visit from me personally, and this was one of those particular points. And so I'm happy to see that in the 3rd year of our administration, we're assisting you in supporting what would be this amendment to finally address the many concerns.
Yes. Thank you, Deputy Borough President, and I appreciate those remarks. Again, my name is Josephine Beckman, and I am the District Manager of Community Board 10 and the applicant in a submission to the New York City Department of City Planning for a zoning text amendment to a BSA Board of Standards and Appeals special permit 73-622, enlargements of single and 2-family detached and semi-detached residences. CB10 is proposing the removal of Community District 10 from its current applicability under the existing regulations. The special permit presently applies to 3 full community districts in Brooklyn, CDs 10, 11, and 15, and a specific R2 area in CD 14. Community Board 10's decision to submit this application to eliminate the special permit is based on 13 years of study and experience with the special permit and how it has been handled by the Board of Standards and Appeals. CB10 believes that the original intent of ZR 73-622 was to allow existing residents a mechanism for relief from noncompliances, allowing modest expansions and an ability in the zoning text to enable growing families to remain in their homes by enlarging kitchens or building additional bedrooms. Board members at that time supported a provision in this section that included community character to be considered regarding whether an application should be granted. Notably, since its adoption by City Planning in February of '98, only 21 special permit applications have been applied, and of these applications, half were disapproved by Community Board 10. Of those that were disapproved, all were approved by the Board of Standards and Appeals. CB10 members have been on record 4 times in the last 13 years to remove this section from Community District 10. CB10 supported inclusion, although at a time there was great citywide opposition and only 5 community boards citywide opted in. The original land use justification for the applicability of the special permit has in practice been predominantly used to legalize existing illegal conditions or to produce luxury housing for speculative sale or purchase. BSA approved all applications regardless of community opposition. BSA never prescribed conditions or safeguards suggested in recommendations made to them to minimize adverse effects on the character of the surrounding community. In 2003, CB10 adopted a planning document called the Case for Preservation Zoning. This document was the blueprint for our request for a district-wide rezoning, which was overwhelmingly supported by CB10, community-based organizations, all elected officials representing Community District 10. CB10 was partially rezoned in 2005 and completely in 2007, thanks to our advocacy and hard work of our local city council member, Vincent Gentili. This zoning section allows non-compliant zoning changes without limitations, which are inconsistent with stricter zoning requirements intended to preserve community character. I brought some boards illustrating the main objections impacting community character. There are no limits, as you can see in these diagrams, on the amount of floor area ratio expansions. They allow horizontal and vertical enlargements of non-compliant side yards and rear yard encroachments of up to 20 feet. These are also available in handouts that I've provided here for the record today. CB10 believes that future enlargement should adhere to the as-of-right residential regulations, proceed within the established relief offered by way of BSA variance or provided under an alternative existing special permit, ZR 73-621, for enlargements, extensions, or conversions of buildings containing residential units that limits enlargements to 10%. Community Board 10's public review process following its certification, we held a public hearing on June 15, 2016 with a broad outreach and notification. The public notification included a 6,000-piece residential district mailing to those areas in which this section of the special permit has been granted in the past. Notices were also sent to our local press, community groups, civic organization, houses of worship, elected officials, prior applicants, as well as real estate brokers, architects, and land use attorneys. Over 100 residents attended the public hearing with 19 speakers. 15 spoke in support, 2 in opposition, 1 speaker had a question, and 1 took no position. Residents were asked to indicate their position on a sign-in sheet that was provided at the meeting, and all were in favor except for 5 residents. The Zoning and Land Use Committee presented its report to the General Board at its duly publicized meeting held on June 20, 2016, following the certification of this text amendment application by the Department of City Planning. The Zoning and Land Use Committee report noted the overwhelming support of all in attendance at the public hearing, reaffirming the application made by Community Board 10. The chair, in agreement with the members of Community Board 10, formally submitted all public testimony to the Department of City Planning to demonstrate the overwhelming community support of CB10's application in a letter dated July 15, 2016 to Carl Weisbrod, Director of the New York City Planning Commission. Today, we appreciate the opportunity to continue this public process, and we are here to listen to public comment and are on hand to answer any questions that you may have. Thank you very much.
Thank you so much, Josephine. I just wanted to take this moment to give the floor to Councilmember Gentili.
Great. Thank you, Deputy Borough President. Good to be with you again. For the many years we were in the City Council together, and I think you might have been among those in 2005 that actually voted for the new zoning, and 2007 in Community Board 10. So we thank you for that also. I just want to underscore my support for this application, and in what the district manager for Community Board 10 has said here. And while this special permit started out with good intention, the fact is that over the years we have seen the Board of Standards and Appeals, because it applies to so few community boards, take the position that even though it's a discretionary permit that they have to vote on, they have taken the position almost as if it were as of right. Because particularly since in the permit consideration, the definition is not there for the essential character of a community, whether granting a permit would change the essential character. The fact that it's not defined as to what that is has led basically Board of Standards and Appeals to view it as almost as a right, given the fact that the community board originally in the 90s allowed it to go in, and therefore it applied to 3 or 4 at the time. Everyone that the community board has come forward to argue against BSA granting it has been overruled by BSA. There are some that the community board has agreed that was proper. But for those that the community board has opposed, BSA has overruled that opposition and voted to grant the permit. So we've come to the realization, I think the board has over these years, that really the only recourse that the community has is to rescind or ask that this permit be rescinded as far as it relates to Community Board 10.
Thank you very much, Councilmember Gentili, and for all of your unwavering support for your community district and advocating for what are most important to them with great input. And you know, these are the checks and balances as council members and government officials that we try to monitor. Everything is nice on paper, but once it's put into practice, we have to make sure that it's not abused nor circumvented for individual gains. And so at this moment, I just wanted to call up Josephine Beekman again, just to make sure that we go through the process of questions we want for the record. Thank you. So Borough President Adams understands that there are 4 known property owners that are seeking to be accommodated by the inclusion of a vesting date that would allow the applications filed before the Board of Standard and Appeals and adopted by BSA to complete home enlargement. Would Community Board 10 be open to considering such an amendment to the application?
I can tell you that in the discussions that we've had at the board, that there was not resistance, but we did not amend our application because we couldn't at that point. But there was no real opposition that was expressed in that regard.
Madam
Yes.
Deputy Borough President, let me just mention that that issue has come up, and I have said that I would consider when it comes before the City Council to include a provision that would grandfather those applications. If we could come up with a real date and wording for that, that would grandfather the existing provisions because of the change in the middle of their application process. So I will be discussing that with the Land Use Division at the City Council as a possibility. I didn't commit to it because I didn't want a flood of applications to hit in the last minute, but we will discuss with Land Use Committee a date certain, I would think, when an application would have to be in, and then we would consider amending it at the time it gets to the City Council.
I appreciate that, and we would like to keep conversations with Borough Hall open so that we understand and support what is that position. So thank you for the clarity. These applications submitted by, nope, that wasn't it. I see, okay. Thank you. So Josephine, if there's anyone here who did not sign up for testimony and you would like to, please see the front desk. Our two interns, Jason and John, are waiting for you. And I want to just make sure that I thank Josephine for the hard work, the diligent effort in illustrating what is just walking tours of what's happening in the community district, as well as what would be this application to mitigate what has been clear as of right, no regard to community district positions that have gone through quite an extensive review of each application, and for the BSA to have just continued to override that decision and that vetting process speaks to why this particular action is necessary. So thank you, Josephine.
Thank you.
At this moment, we're going to call the first witness, Janine Bardo, spokesperson, Diker Heights Civic Association.
Good evening. I'm giving a testimony for Fran Bella Marone, President of the Diker Heights Civic Association. On behalf of the officers and members of the Diker Heights Civic Association, I would like to state our support for Community Board 10's request for repeal of Community District 10 from ZR Section 73-622 special permit. In 2005 and 2007, Bay Ridge and Diker Heights sought and successfully obtained contextual zoning in order to stop and prevent increase in density, which was having an adverse effect on the character and stability of these communities. The Diker Heights Civic Association was proud to play a role in support of this effort. Once again, we are lending our voice to a zoning matter affecting our community. The special permit ZR 73-622 was originally approved by Community Board 10 in 1997 in an effort to accommodate growing families so that they would not have to leave the community because their family had increased and their home no longer afforded them the space they needed. However, over the years, the special permit has been abused and used instead for luxury expansions, speculative purchases, and legalizations. Each special permit request that came before Community Board 10 was reviewed individually on the merits. In some cases, the Community Board approved the applications, and in some cases, they were not approved. However, regardless of the recommendations of the Community Board, the Board of Standards and Appeals had approved all of the applications. ZR 73-622 mandates that the alterations made pursuant to the special permit must be in line with the character and nature of the surrounding area. Each time the Community Board would state that the application was not in compliance with the character of the surrounding community, and as such should not be approved, the Board of Standards and Appeals would approve it anyway. Which entity is more equipped to judge the character of the community? I dare to say that which is closest to it. In this case, that would be the Community Board, not the Board of Standards and Appeals. The Community Board repeatedly asked the Board of Standards and Appeals, as well as the Department of City Planning, for their definition of community character, but received no such definition. How can the Board of Standards and Appeals decide on community character if they are unable to provide a definition of such? Diker Heights has been the victim of illegal home conversions that are draining city resources, straining the infrastructure, creating substandard housing that is dangerous to its inhabitants, as well as the surrounding residents, and altering the character of the community. This is an illegal end run around the contextual zoning that our community fought so hard to implement. In many cases, the special permit has been used to increase density and legalize illegal conversions. We cannot afford to have this continue. ZR 73-622 was initially submitted to the Department of City Planning for applications citywide, but ultimately limited to 7 zoning districts. They were Brooklyn Community Districts 10, 11, 12, 14, 15, and Staten Island Community Districts 1 and 2.
If you could wrap up.
Okay. Community Board 10's initial, due to the lack of a definition of community character and the Board of Standards and Appeals' complete lack of regard for Community Board 10's recommendations, it is time for the removal of Brooklyn Community District 10 from ZR 73622. Thank you.
Thank you. I'd like to call up Robert V. Casara, President of the Brooklyn Housing Preservation Alliance. And at this moment, I'm going to excuse myself, but I will leave you in good hands with both Councilmember Gentili and our Director of Land Use, Richard Bayrak, who will continue this hearing.
Good evening. I'm Bob Casara, lifelong resident of Bay Ridge and Dyker Heights, and I am opposed to the special permit ZR section 73622. The community of Bay Ridge and Dyker Heights has its zoning set up to protect the character and charm of the community. In the early 2000s, community board, along with the elected officials, pushed for and got the city to downzone CB10 because of the as-of-right abuses we saw happening in our community, such as single-family homes being torn down and replaced with much larger, out-of-scale and character multifamily buildings. We came to an agreement and the compromise with the city, and most of our community was downzoned with the exception of corridors, certain corridors along 4th Avenue and a few other areas as well. Those areas were allowed to increase the height of buildings while maintaining the rest of the low-rise buildings. Based on what I have learned, have not been that many requests. Approximately 20, for just a few, have been given permission to increase the size of the buildings in our community by Community Board. Community Board 10 is very diligent in safeguarding the community, but the Board of Standards and Appeals approved all applications despite instances where the Community Board 10 members raised objections that the expansion projects did not conform to the intentions of the statute and adversely affected community character. In many cases, ZR 73622 permit applications that were approved, the result is that it doesn't reflect the initial intent of the special permit, but resulted in many enlargement applications for luxury expansions, speculative purchases, or legalization. This has happened big time in other areas such as Manhattan Beach, Madison Marine Homecrest, covered by Community Board 15, where this special permit also applies. It has completely changed the neighborhood character. Times are changing even further. Our community is now under siege by the unscrupulous developers and investors who are illegally converting our predominantly 1- and 2-family residents into SROs. This in turn is causing overcrowding of our schools 170%, health hazards, strains on our sanitation services, risks to our first responders. These developers are illegally converting them under the very noses of those of the Department of Buildings. The DOB should be preventing this illegal behavior, but they and other city agencies are unable or unwilling to stop it. If left unchecked in time, it will break our zoning. Developers and investors will seek to enlarge their property in order to make SROs that contain even more units. I fear that the special permit ZR section 73622 will only give these opportunists more of an incentive to cause destruction to our community, thus changing the very character of our community and eliminate the reasons why so many of us for so long have called this place home. Once the tipping point is reached, our community will be changed forever and will not be a place that any of us will recognize or wish to continue to live in. Not only do I call for the special permit CR 622 to be rescinded, but I also call on the Department of Buildings to stop issuing new Type 2 building permits in our community until the building codes can be changed to prevent any further destruction of our housing stock. Special permit 73622 must be rescinded to halt and stop the further destruction of our housing stock and character of our community. I call on the Honorable Borough President to vote against special permit 73622 and help preserve Bay Ridge and Dyker Heights. Thank you very much.
Next speaker is Barbara Jermalt.
Hi, my name is Barbara Germack, and I am speaking not only as a member of the Community Board 10, but as a long-term resident of Bay Ridge. I speak as well as someone who has worked her whole career in the district. To me and to all of the residents, we don't just live in an apartment or a building, we live in a community. And when unfettered development comes in, the community is no longer. So I am with the Community Board 10 in urging this special permit to be repealed. Thank you for your help.
Thank you. Our next speaker is Brian Walsh.
My name is Brian Walsh. I'm a lifelong Bay Ridge resident and a homeowner. Like most homeowners, my house is my greatest asset, so I support the text amendment to eliminate the special permit from the CB10 district. As the zoning resolution is now written, almost any homeowner can find themselves in a situation where if your neighbor applies for a special permit to overbuild his house, there would be nothing you could do about it. You could write letters to the Board of Standards and Appeals. You could attend public hearings to voice your opposition, but in the end, it would not influence the outcome. I say this with confidence because I experienced it personally. Then, once the permit is approved, it's a matter of time before you find yourself living next to an overbuilt eyesore, which will impact not only your quality of life, but possibly the value of your home, if, for example, it were to diminish its curb appeal. So to conclude, I'd like to make one point. As homeowners, we have hazard insurance to protect us from an unexpected calamity. If this legislation is passed, it will protect you from the unfortunate experience of having your neighbor's house receive a special permit and become overbuilt. I urge everyone to protect their investment and support this text amendment. Thank you.
Thank you. Next speaker is Stephen Harrison.
Good evening, and thank you for this opportunity. My name is Steve Harrison, and I'm a lifelong resident of both Brooklyn and Bay Ridge, Community Board 10. Only at that time it wasn't Community Board 10. They didn't even have them. I'm a past chair of Community Board 10, and I've been the chair of our Zoning and Land Use Committee at least twice for a total of more than 10 years. I was a leading proponent during our long fight for rezoning in the early 2000s. I've long advocated for the elimination of the special permit now before you. I believe it is the antithesis of good zoning. For that reason, I heartily endorse Community Board 10's application now before you. And the original driving concept behind the special permit never really made much sense to me, I have to say that. The purpose was to allow young homeowners who were already entrenched in their homes and communities to make modest, non-conforming enlargements to accommodate growing families. But the only real restriction on the enlargement was that it would conform to community character. Now, community character is an amorphous, subjective term. It's undefined by the zoning resolution. It's the functional equivalent of saying that the enlargement should be beautiful or gorgeous or really neat looking. In short, it means absolutely nothing. And because it means nothing, the Board of Standards and Appeal has never once applied that standard, probably because they can't agree on what community character means either. It just grants the application, essentially making it an as-of-right application. That's what this special permit has become. The result has been a little bit bizarre. The effect has been to give a helping hand to growing young families, not to give a helping hand to growing young families, to allow them to stay in their homes through minimal zoning relief. Instead, the effect has really been to nullify the board's rezoning in the applicable zoning districts. What's the point of requiring 30-foot yards in the main zoning if you're only going to say, well, you know what, you can have 20 feet if you just make a simple application that's granted almost as of right by the Board of Standards and Appeal. The same thing is true, say, with floor area ratio. Now, what's the point of any absolute limit in the principal zoning if you can just bypass that just simply for the asking? And I want you to remember that the Board of Standards and Appeals has never said no to one of these permits. And curiously, the people who have benefited from this special permit are not the struggling masses that it was intended for. The beneficiaries are those with ample means, those who simply want more luxurious accommodations. Now, that's not wrong. The applicants are welcome, productive members of our community, and they are well within their rights under this special permit. But it's not what was intended when that special permit was added to our zoning. And despite the hoots and the hollers of our neighbors who unfairly have their light and air cut off, we at Community Board 10 are powerless to stop it in the face of a non-adaptable Board of Standards and Appeals. There are other ways to apply for enlargements, but these devices, as of right enlargements, variances, and a potpourri of other special permits, all come with tighter controls and restrictions. We are not going to miss this one totally out of control special permit. I thank you for your time.
Thank you. Next speaker is Ed Jaworski.
Good evening. Ed Jaworski, President, Madison Marine Homecrest Civic Association in Community Board 15, where we've been blessed to have one of the highest numbers of special permits in the city. When this came into being in 1998, Guy Molinari was Borough President in Staten Island. And he said in a letter to Chairman Joe Rose at City Planning, although the proposed BSA special permit would initially appear to offer certain benefits to individual property owners, upon closer examination, the proposal bears within it what is considered to be critical flaws that make it something of a Trojan horse. Fernando Ferrara, the Borough President of Bronx at the time, suggested in his letter of opposition, enforcement of existing zoning regulations to prevent illegal conversions is practically non-existent and probably will remain so in the foreseeable future. The Borough President of Queens and of Brooklyn at the time also rejection of the special permit. In fact, I saw a letter from Howard Golden, I think it was, who said it's going to lead to problems down the road. We've seen within Community Board 15 a great deal of abuse of the special permit. Since it came into being, we'll hear a couple of statistics. In 1990, before the special permit existed, in Community Board 10, there were 2 demolitions. In 1998, the year it came into being, the number of demolitions went up to 22. In Community Board 15, there were 3 demolitions in 1990, pre-special permit. It went up to 41 the year that it came into being. Other abuses. The chair of city planning, Joe Rose, at this time, in 1999, sent a letter to James Chin, who was then chair of the BSA. Final sentence about a specific special permit that was before the BSA. The provisions of the special permit do not apply in this case, 73-622, for the BSA to grant special permits for enlargements of existing homes, not new construction. The plans filed with the BSA for this project clearly indicate the proposed house does not enlarge any existing structures on the site. It was a demolition and a new construction, even though city planning suggested to the BSA they reject it, they were overruled. The BSA granted it. Right now, we have a special permit within Community Board 15, and as I mentioned, Community Board 15 has a habit of rubber stamping, just like the BSA does, where they got a head start. It just went to Community Board 15 in June. They started extensive demolition and excavation in April. It's going to the BSA soon. A couple of recommendations. One, Community Board, I support Community Board 10. As far as the other community boards, I would recommend a suspension, a moratorium on special permit 73-622 for a year or 2 until all the abuses are studied and corrections made, including the collection of hundreds of millions of dollars in outstanding fines. And also, I would instruct city planning, city council obviously has to do this, instruct city planning to define character of a neighborhood. We also, right now, there are no existing standards to analyze the effective character on a neighborhood. It's totally a subjective decision by the BSA, and they've been bullied into positions, a one-dimensional position, by land use attorneys. I strongly recommend that besides repealing CB10's participation in it, that you instruct city planning to define the expression character of the neighborhood. Thank you.
Okay, thank you. Our next speaker, Jordan Most.
Hi, Jordan Most. So I guess it was the deputy borough president who was up there before, made mention of several applications that are outstanding, and of course the council member spoke to the possibility of a vesting provision. I work for the office who filed what are, to be precise, there are about 3 applications that are in various stages in the special permit pipeline that I'm simply here to advocate on behalf of the vesting provision, so that the application, one of which was approved by both the Community Board and the Board of Standards and Appeals as recently as, I think it was in April, that they're actually, even though it was approved, they're affected by the vesting, by the possible removal of CB10 from the special permit, and that they do also need protection under this vesting provision, which I actually have a copy that I've drafted. I'm happy to distribute. And another application that was filed on April 1st of this year that had, and when I say filed, it doesn't mean that we raced to file it on April 1st. We had been hired to begin work on that application long before we ever heard that there was any discussion of removing CB10 from the special permit provision. That application is at the Board of Standards and Appeals. It was actually heard by the Community Board. The Community Board voted against it, although I think it was a little conflicted because it was almost at the exact same time that the hearing was taking place for removal of CB10. I'd like to think that it might have even been approved if it hadn't had that timing conflict at the Community Board. It was difficult, I think, for the Land Use Committee to look favorably on the application while simultaneously voting to remove it. Those are just my personal insights, that's all. Nevertheless, we've just got a notice of comments from the Board of Standards and Appeals, so it's moving forward at the BSA, but it's not going to have a decision for many months at the board. Another application was filed, I think, in the middle of June at the Board of Standards and Appeals. The Community Board, of course, has copies of that application, and so that means there are really only 2 unvoted items. One was, the earlier one was approved. There had been discussions, I know some of you may be aware that there was another one that we actually also happen to represent. We haven't been able to file that yet at the board. We're not sure if it's actually going to be a special permit or a variance. It's a very, very small enlargement, 130 square feet, but there are some technical questions that may prevent it from using the special permit. So we're working on that. So again, so I'm here to just advocate and to ask that it be considered. I know the council member had mentioned there was concern that when word got out that there would be a flood of applications. There has been no new applications, as I understand, other than those 2 open applications that are there, the one that was previously approved, and then there's this one possible application. So that's really it. I'm happy to answer any questions if there are any.
Thank you so much.
Okay.
Next speaker is Victoria Hoffmo. Thanks.
Good evening. I am Victoria Hoffmo, founder of the Bay Ridge Conservancy. As to revoking the special permit in Community District 10, all I can say is hallelujah, it is about time. In 1997, which is almost 20 years ago, when the New York City Planning Department offered each community to vote on the special permit, I spoke against it. The board had good intentions, but I was concerned about how it would be misused. And that's exactly what has happened. So I have been at the Board of Standards and Appeals at least 6 times to prevent onerous construction projects that far exceed minor alterations, and have instead changed the entire shape, bulk, materials of a home, as well as the content of the block, context of the block. One can only object to these alterations in terms of character, which never seems to work, no matter how many photographs you bring. The last time I went to the BSA was 2013. It was on behalf of Mrs. Walsh, Councilman Gentili, CB10 Chair, Josephine Beckman, and many residents were there to support Mrs. Walsh. Unbeknownst to us, there was also another group from Dyker Heights here at the same time, also testifying against a special permit. And to our surprise, BSA Chair Shrivanithan suggested that we revoke the special permit since we were there all the time testifying against it. And I concur with the commissioner. Since the implementation of the special permit far exceeds what CB10 had expected, it needs to be revoked. And since it is being used in projects that are in conflict with architectural zoning change, it needs to be revoked. And since the 621 special permit already allows for minor alterations, thus fulfilling CB10's original intention for voting for the special permit, it needs to be revoked. The fact that those trying to stop this revocation or those that are using it as a loophole just validates what we believe. So I suggest that we follow the advice of former Commissioner BSA Shrivanithan to revoke the special permit. Thank you.
Thank you. Next speaker is Stephanie Joseph.
Good evening, ladies and gentlemen. I'm a member of the Brooklyn community. I know you live in Community 10, but I live in Bedford-Stuyvesant. Downtown Brooklyn is really my home. I've worked here for the last 30 years. As you know, they tore down the mall, Albert Square Mall. I work there, and I am project management. I love the place. I love downtown Brooklyn, but it's changed, and we have to come to terms with that. You want to keep your community, of course, habitable for you and your children, your space. And I can understand that. But they, like you said, they've gone ahead and they've built some high rises. Okay, we're going to have to deal with that because they're here now. And my issue is we need to deal with reality. First of all, the seniors, they're not going to do good in these high rises. So we shouldn't even look to them for advocating for them to be a part of that community. Not that I'm prejudiced, but that if you're a senior and you're in apartment 22 on 22F on the 22nd floor and the elevator's breaking down for whatever, Katrina's mad at you, well, the water's coming in. They're flooding, so they can't use the elevator. Am I right or wrong? You know, these seniors can't get to the 22nd floor. So it's going to be very difficult on them. Also, parents with children. Now, they're going to need daycare. Probably you have separate daycares already set up in the community. All right. A lot of these high-rises, they're offering on-site daycare facilities. They're offering gymnasiums. But these are actually for people who are working, middle class, probably a little younger than our baby boomers, because we know our baby boomers, we're getting on in age. So at the end of the day, our community is actually moving into the 22nd century. We've already dealt with the 22nd century. We had our dreams, and now we're putting them into effect. So my thing is this. We need to watch out for our children, because our seniors are not going to be able to make those high floors. Not good for them. Also, our children, they truly are going to need the daycare. Am I right or wrong? Now, the thing is parks. How are we going to get to our park with this big old high-rise in the way? We have our children's in our strollers, their little bicycles. They're not going to want to go around these big old high-rises to get to their park. So what are we going to do about that? High-rises have to accommodate the children. Parking may be very much so scarce, as is a lot of these parking lots downtown, and we know we have a few. They're being used up for what? To build high-rises. Okay, let's deal with it. They're going to have to find some way to park their cars, because we're not going to have them parking on the street, because they can't park on the street. How are the kids going to get to school? How are the school buses going to get here to pick up the kids in the morning? We had that up in the Bronx. They had a big thing in the Bronx. The school buses couldn't get the kids because there was a bunch of building going on up there. Up there, I think in the Throgs Neck area. And anyway, let's just do reality. This is a senior and an infant, basically a minor issue, because us middle-aged people, we can sort of like get into the community and deal with, navigating through the community. But these children and these seniors, they need special care. So I'm advocating for them to get some extra treatment in this high-rise industry, and we can ask them and advocate for them to do that. Thank you.
Thank you. I have one last speaker on this item. Maria Roca. If anybody else would like to speak on this item, again, we do have speaker slips in the back that you can fill out.
Hi, good evening. I do not live in Bay Ridge. I am not under the guidance of Community Board 10, But I live in Sunset Park, Community Board 7. And about 25 years ago, we began to see the undoing of Sunset Park. Speaking of community character, illegal conversions, abusive use of land, destruction of facades of beautiful row houses. And I'm here to support Community Board 10. I'm here to support Dyker Heights and Bay Ridge in their quest for control of the future of their community, because no one in Sunset Park 25 years ago who could have done something was interested in protecting Sunset Park. And if you drive through Sunset Park today, what you see on many streets and many avenues is vandalism. It's tantamount to vandalism when beautiful blocks have been destroyed because of the lack of guidance by government to new owners. So I don't have any skin in the game, so to speak, officially, but whatever they're doing, it's great that these folks have taken the enormous amount of time that it takes to fight something like this, that care about that community, because unfortunately in Sunset Park, there were only very few of us who saw what was coming. And we did not get the support that could have stopped the pillage of Sunset Park. So I beg you to please support these folks so that the same thing doesn't happen to them. Because if we don't have communities, we don't have boroughs, we don't have a city, and then we don't have a country. And we've seen it in Sunset Park, we've lived it, and it continues, and it's slowed down a little bit, but it still continues, and still we are not getting the attention that this problem demands. The overcrowding, we have it. We have the sanitation problems. We have water problems. DEP lives in Sunset Park nowadays because of the overcrowding. Our systems, our water, sewage systems are being overtaxed beyond. Our neighborhoods were not built to accommodate such large numbers of people. That's just the way it is. And it just doesn't mean that we have to change everything up, turn everything upside down, and build where the infrastructure of this city is not prepared to accept these large numbers of people. And it's just going to keep going. And we have plenty of land in New York City. We have plenty of other places to build. We cannot change the character of the community, of a community, because people just decided that they have money and that they have money to burn, and they're going to do whatever it is to a community because they've decided to do so. It just doesn't work. It's not the way a civilized society works. So I beg you to support them, and I'm certainly here to support their hard work. Thank you.
Okay, thank you. So all the speakers who have submitted slips have had the chance to speak, so I'm going to close calendar item number 1 because most people here will be not necessarily staying for the next calendar item. Just want to make people aware that the City Planning Commission will hold a next hearing on this item. The review period for the Borough President and the Community Board is joint. It ends, I believe, August 10th, so a hearing date in Manhattan at 22 Reed Street, a Wednesday soon after August 10th would be the hearing date. I've not seen a date yet, but you could follow their website if you want to follow and attend the hearing at 22 Reed Street. And then the commission, after their process completes, it will go to the City Council. So the Subcommittee on Zoning and Franchise of the Land Use Committee would be holding the final hearing on the matter. So that might be sometime late September into October. So again, I thank all who came to contribute tonight to share their thoughts. And so the first calendar item now is closed. Thank you. So going to call now calendar item number 2, 150360ZMK and 160379 ZRK. We'll take a little bit of a pause to allow our applicant to get set up, a representative, and allow people to leave. that are not interested in this calendar item. These applications submitted by 14-18 Carroll LLC seek a zoning map change from M1-1 to a R6B district and a zoning text amendment to designate a new mandatory inclusionary housing area for the properties known as 14-18 Carroll Street in the Columbia Street Waterfront District neighborhood of Brooklyn Community District 6. Such actions would facilitate an extension of an existing neighboring R6B district for an envisioned 4-story, 10-unit residential building, including 6 off-street parking spaces. Additionally, the development would result in a payment to the city's Affordable Housing Development Fund in accordance with the mandatory inclusionary housing program. Community Board 6 has not yet voted on this application. Borough President Adams will hold off making any decision until he hears from the Community Board. The representative from the application, Todd Dale, please state your name for the record and present the application.
Good evening. My name's Todd Dale. I'm here on behalf of the application. As you very clearly stated in your introduction, this is an application for a zoning map amendment from M1 to R6B. On this particular map, it's this area outlined in red, 3 tax lots that front on the south side of Carroll Street. 14 to 18 Carroll Street is the current address. It is within block 352 of Brooklyn. The site is currently vacant. Records indicate the site was previously developed with a 3-story residential and mixed-use building. Mixed-use buildings comparable to the remaining buildings that are already on the south side of Carroll Street. As many of you may be aware, this particular area has been subject to several variance and rezoning actions comparable to what is proposed, seeking residential development from March of 2007 all the way up through 2011. This includes the Carroll Gardens and Columbia Street rezoning approved that rezoned approximately 86 blocks within Community Board 6 from R6 to R6B, which is the R6B zoning that's proposed. This proposed zoning map amendment would facilitate development of a 10-unit residential building. This rendering here gives an idea of what is proposed. Of note, the plans that were submitted with this application, even though Department of City Planning will not, should they approve this, designate particular plans, the property owners are committed to the plans and everything that's been shown. A lot of care has been put forth into these designs, and we think that it fits very well with both the existing buildings that are in the area. The total square footage for this building would be 12,540 square feet. That would be an FAR of 2.0. There would be 6 off-street parking spaces provided. Flip to the... This shows 6 off-street parking spaces provided with access from Carroll Street. And 10 dwelling units ranging from 2 to 4 bedrooms within the subject building. The one item to note, as noted, this would be part of the mandatory inclusionary housing program, and that is one of the actions it sought to designate this and establish an MIHA area. In conjunction with the mandatory inclusionary housing, there would be a 0.2 FAR bonus that would be available. Should that bonus be taken, the proposal would be to construct on top of the building a penthouse that would not be visible from the street. So the site plan would remain the same, and the actual structure as depicted here would be the same. It would be approximately, this 0.24 I think is approximately 1,200 square feet that would be allowed up onto the top of the building, and that goes in conjunction with the design that's been proposed to work with the area. As was stated, the proposal for the mandatory inclusionary housing would be a contribution to the HPD Affordable Housing Fund. This is in lieu of the other options, which would have on-site affordable housing, which are really designed for larger developments. With respect to the contribution to the fund, HPD has not yet set forth the parameters, but the property owner is willing to conform and comply to the contribution requirements. We would also note that as we discussed both with the community board and with the Borough President's office, we would be in full support that those funds go to buildings within Community Board 6 and ideally affordable housing units close to this particular neighborhood within Community Board 6. Just as some background for those who aren't familiar, there is a mix of uses in the area. There really is residential on all sides, primarily on Carroll and Summit going back forth. There's commercial use on primarily on Columbia Street, and then any manufacturing transportation uses are within the existing M1 district. Of note, this does, I'm not sure if I've got the right zoning. On the zoning map, this might be easier to see.
And you could always pull out the mic if you want to move yourself closer.
Yes, that'll be easier. So the proposed zoning right here is what would extend the particular area. This is the current zoning, and the proposed zoning would change the R6B. This lot does border along the backyard garden, a public garden. We did, at the community board meeting with Community Board 6 in June, speak with representatives from the garden who were in favor of the project. There's also a meeting scheduled next Wednesday with members of the community, community members who are involved with the backyard garden to discuss with them any concerns or suggestions they might have regarding the project. With respect to the community board, they have not voted yet, but I spoke to the district manager. They are closed over the summer, but they are conducting an executive session August 1st, and at that time, the executive session, they will issue a vote and issue their final decision on the matter, which would then be circulated to all parties. Few additional items. In discussion with the Borough President's office, we know there were certain issues that were raised that we'd like to address now. First, I already spoke. The plans as shown, even though city planning won't set forth specific plans, we are committed to these particular plans because they were received favorably by the community board, and we believe that they fit well with the particular neighborhood. Again, we reiterate our support for having any funds donated to the affordable housing, HPD's affordable housing fund, to be in Community Board 6, and specifically this area, even though that program does not have parameters set forth yet. There was a question about why these properties, why properties to the west weren't included in this particular rezoning. We would say that that was the decision in conjunction with city planning, but we would also note we wonder why this lot wasn't included in the previous rezonings that took place, specifically in 2011, because this is a vacant lot. It seemed a primary site to be included in such a rezoning. As far as other properties to the west not being included in the rezoning, these are permitted residential developments that are pre-existing, so there really is no need to change the zoning in order to make these buildings come into conformance and compliance. I know there was the questions about the backyard garden. As I said, we do have a meeting scheduled on Wednesday. There's a question regarding sustainable construction practices. I would just note that this issue was also raised by Community Board 6, and we spoke with them about it at the time of the meeting. The developers have made efforts to explore sustainable practices that would be feasible in the project of this size. These measures would also include anything like basic things that include the use of high efficiency appliances, a white, green, or blue roof, and high efficiency windows, but the developers are exploring those opportunities. And then finally, there was a question with regard to minority-owned businesses in connection with the development. Because of the stage that this is at, the developers have not selected contractors this time or reached out to contractors, but the owners are an affiliate with Stryker Construction, a firm that has used MWBE subcontractors in the past, and they are definitely open to utilizing MWBE subs on this project going forward. Happy to answer any questions.
Thank you. Okay, so given that community board concern, because the requested zoning does permit a 5-story building with the 5th floor, not necessarily being fully set back, but certainly partially set back, and obviously this is the drawing presented that the community board actually liked, and they even liked the actual layout fenestration, but you just mentioned during your presentation about an extra actually 10%, 9% to go from 2 to 2.2. So are you saying with the mandatory fund and using the 2.2 that you would actually solve that by putting a partial fifth floor?
Yes, yeah, because the fund, I mean, the fund is still shaking out the developments, but the extra 0.2 would be permitted as a contribution to the fund. The idea is to do a partial floor on the top that would not disturb the street front. It would fit within the R6B zoning, the setback
Right.
with the height, so it would be
So
permitted.
you don't look at that as making the building a little deeper to accommodate that extra 9% floor area?
No, there's no
you don't
plans to
believe
make
that's-
that building deeper because that would, we believe that would push back towards the garden, which,
Right.
and we feel that the yard that's provided right now is beneficial to us to provide parking and also beneficial to the garden to still provide
Right.
air and
So
light.
that wasn't brought forth at the community board hearing and with the committee, so we'll look to hear from what the community board shares in executive session
Okay.
to the borough president.
Sure.
And then whether it's 4 stories like this or whether it's with a setback, again, because the zoning itself isn't a mechanism that guarantees that facade, what steps might your client take to give a sense that you're not going to be placing, because the zoning does allow to go straight up, what sense of comfort would your client consider to give confidence that the building would either be this or a setback that was reasonably set back from the street?
I understand that, you know, the concern and the fact city planning does it. I believe we'd be willing to write a letter to the community board, community board and or the borough president's office speaking about the intent that any extra floor area that would be permitted as part of the mandatory inclusionary housing program would be used in the manner that we're describing here so as not to decrease the yards or change the facade.
And if the community board was not opposed, or community residents were not opposed of the building going further back towards the garden, and how it relates to the 2 neighboring sides, is that something the client would consider? Do they feel like it really functionally that it has to go on to a higher floor? Is that something you could look into?
We could definitely look into it depending on what the community board said. As I said, a lot of effort was put into these plans originally without that 0.2 FAR. The idea was to really come up with something that would fit within the neighborhood. So, the initial thought is that the partial penthouse, which would have a restricted view, would be the least obtrusive to the area. But if thoughts were extending the building, it's definitely something we'd be willing to
Okay,
look at.
so we will try to get word back into the community and the
Sure.
community board, so in a timely fashion to get a sense where the priorities lie.
And you know what, we can reach out, we're on good terms, we can reach out
Great.
to Craig and
Great.
something like that and talk to them and to see if that would be, a question that might be raised.
Thank you. So, and again, you brought up before about the inclusionary fund, and obviously it's still not worked out with the city. The nearby sites, there are a couple of sites that HPD has in its NIHA program, and I believe it has a designated developer, and these funds could help either improve the level of affordability of those units or at least help the financing happen sooner so we could see those lots be completed sooner rather than later, because a lot of them go back into the 70s when sewer projects back in the neighborhood.
Right.
So
We're in full
appreciate-
support of what we can do to
yeah, and if
keep
you're
it in the
providing
community.
a letter to us
Okay,
on that
sure.
matter, the prior matter with the plans, in fact, attaching rendering that may show, how the added bulk, if it's vertical or horizontal, might be, and plus the facade, that'd be greatly appreciated. And then the borough president, it is his policy to promote the use of sustainable and renewable energy resources to advance a sustainable future in Brooklyn, as well as promoting practices to obtain water runoff. So in addition, what you mentioned about blue, green, and white roofs, and even green and blue roofs merge, because we do have systems that do both. We also like to see passive house design, so we'd hope you'd bring that back to your architect. In fact, passive house, there's some examples. If you just walk down Court Street, actually just outside of District 6, a few blocks down, I believe at almost at the corner of Court and Pacific Street, and there are some buildings throughout Brownstown, Brooklyn that are doing this model. Plus, in terms of bioswales in the streetscape, adds more greenery to the streetscape, so part of Builder's pavement plan, perhaps looking at as part of Builder's pavement plan to consider bioswales. And even in the rear where you have the parking lot, that there are different ways of doing pavers that allow the water to not run off as much. And given that we have the garden that overlaps roughly half the yard, if to look into whether there may be systems where you're capturing your rainwater, not just from the lot, but even the building, that might help be an added water source in synergy with the garden. If you could take a look at that and let us know what might be feasible. And I thank you for bringing up the issue of the MW-type firms, and it's not just the contractors, but also the material suppliers, because we believe these locally based firms and MWB firms also may have a better opportunity for hiring local to put Brooklynites to work on the projects. We would look forward to that. So I have no additional questions. We have no signed speakers. If anybody here does want to speak, we'd ask you to fill out a slip. Anybody would like to speak before we close the hearing? We'll let you fill out the slip right after to save time for those. You can come right up and then just ask you to sign the slip before we complete. You could angle the mic down.
Once again,
Say your name for the record again.
I'm sorry. My name is Ms. Stephanie Joseph, and as I said, I'm from Brooklyn. And I know this Carroll Gardens area because I worked in Red Hook. I used to take the 65 bus down there, and they did a bunch of redevelopment and beautiful work they did down there back in 1986, I think, 7. Nice work. So there's a lot there, and you want to bring some more revitalization into the area, like by developing this new structure, rehabbing, I guess, right? You're going to gut it and rehab it?
New construction.
Oh, it's fake, so there's nothing there. Right, so you're just going to build it from the ground. Great. And you're going to put in a penthouse that's off the main exterior of the building, so it won't be noticeable on the street. That's what you're saying? Basically. And there's a garden in the back, and you don't want to sort of like make the garden less attractive by having the building, the 5th floor, sort of like looking like it's leaning over the garden?
We try not to do this as a question.
Okay, okay, good. But I'm trying to figure out what he's saying, because I was there when they did the first revitalization of Carroll Gardens. That's what we're talking about, right? So basically, I'm all for the program, and good luck.
Okay, thank you. All right, so we have no additional speakers. The hearing on these items is now closed. Thank you for participating in this public hearing. The Borough President will review the applications we heard today and will soon submit his recommendations to the City Planning Commission. Borough President Adams would like to take this opportunity to remind you that the City Planning Commission will hold a public hearing on this item and the prior item. The hearing is now adjourned. Borough President Adams would like to remind you that those viewing on the website can submit timely comments by email to askeric@brooklynbp.nyc.gov. Thank you.